Hello, and welcome to Alcohol Facilitated Sexual Assault. We're going to have a conversation today with my colleague Jonathan Kurland as part of our Foundations of Sexual Violence Prosecutions. We are both attorney advisors from AEquitas, and our goal is to provide you with really, hopefully, innovative and informed information that is also practical and something that you can apply to your work right away. Want you to know more about AEquitas, check out our website. We've got lots of resources, webinars online, written resources. You can also reach out to us and we're able to provide you with 24/7 consultations to answer case-specific questions, even conduct research on your behalf. This is our website and all of our social media platforms. We are always pushing out training opportunities and new research, promising practices. So if you are online in your professional capacity, please follow us and we can make sure that you're getting that information. This series is supported by the Office on Violence Against Women, the Department of Justice. We thank them very much for their support, although what we say may not necessarily reflect their views. We're also going to give you guys the fair use doctrine, and this just says that we do incorporate the latest information, research, promising practices into our materials, and we share that with you using the fair use doctrine. Okay, so we're going to get started. Jonathan, I know you're excited because this is one of your favorite topics. When we talk about alcohol-facilitated sexual assault, one of the things we want to impress upon you, and we have another part of this series as well, where we talk about that offender dynamic, which is to understand that there is this level of premeditation and predatory behavior that we need to make sure we're looking for when we look at offenders who perpetrate alcohol-facilitated sexual assault. Experts can really help us in this work. Today, we're going to specifically talk about toxicology evidence and how experts can help us with that. And then how do we present this to this case at trial to really make sure that we're staying offender focused so that the jury also views the evidence through that lens. So welcome, Jonathan. I don't know if you want to give us a little intro.
Sure. Thank you so much, Jane. And I am anxious to have this conversation with you about alcohol-facilitated sexual assault. Folks, my name is John Kurland. As Jane indicated, I'm an attorney advisor with AEquitas. I've been with AEquitas for about 5 years. Prior to that, for 16 or 17 years, I worked as a prosecutor in Berks County, Pennsylvania, which is in southeastern PA. When I was prosecutor there, I supervised the prosecution and personally prosecuted cases involving sexual violence, intimate partner violence, child abuse, homicide, things of that nature. Great job. I still conceptually think of myself as a prosecutor, which is why this gig with AEquitas is so fantastic, not just because I get to work with people like Jane, but because I continue to get to work with prosecutors in these issues and just observe these practices from all across our country.
Yeah, I think that's one of the greatest benefits, and hopefully a benefit to the field as well, is that we get to work with prosecutors in all different jurisdictions, all different types of jurisdictions. Across the board, they have challenges related to alcohol-facilitated sexual assault and how to prosecute these cases effectively. But we can then take from the great practices we hear and then sort of fold them into conversations like this and share them more widely.
I agree.
So we're going to start off with, I'm going to ask you to reflect upon this statement.
Who needs force when you have alcohol? And this is really a phrase we use a lot at AEquitas when we're talking about alcohol-facilitated sexual assault and the phenomena of it. And it's sort of what it takes. It challenges the sort of stereotypical conception of sexual assault being something done with a lot of explicit force and violence, maybe perpetrated by a stranger. And while those kinds of sexual assaults and rapes, they do happen and they do occur, it's by far the minority of sexual assaults. And the reason why that it's the minority of sexual assaults is because it's the kind most likely to be prosecuted, the kind most likely for the offender to be held accountable, or at least an attempt for that offender to be held accountable, because it is so explicit. But a lot of sexual assaults, and where most sexual offenders are perpetrating and living, is this idea where they're going to not have to risk being caught as much. And alcohol is a great tool for the clever offender to use to perpetrate sexual assault. Why? Because alcohol, it's culturally accepted. There's lots of places you can go where it's socially acceptable to drink, where people are drinking. There's multiple environments where you can even binge drink or drink too much. And when you drink too much, or when someone is consuming alcohol, they become vulnerable. They become vulnerable because their ability to protect themselves is reduced. Their judgment can be reduced. Their motor controls can be reduced. Their ability to fend for themselves is minimized, which makes them easier prey. And people who drink are usually, what they talk about is usually minimized and discounted, which makes it a great place for an offender to find a victim. And you compound that too, there can be a gender double standard too, in the sense, obviously not every offender is male, not every victim is female, but predominantly offenders are usually biologically male, and victims are biologically female. There can be a minimization of an offender's conduct when they've been using alcohol, and a spotlight put on a victim's conduct when they're using alcohol. So
Yeah.
that's what makes it great for offenders.
Yeah, and so when we have alcohol, you don't need force, because alcohol is sort of doing the work for you. And one of the things that I heard someone say once that struck me was, a perpetrator is only going to use the amount of force necessary to accomplish their goals, and so they can get away with not having to use excessive force or a weapon when they have alcohol as a tool to perpetrate. But along with that comes a lot of challenges with the prosecution of cases where alcohol is involved. And, we're going to talk about alcohol. We're going to talk a little bit about, drugs as well. This really is applicable to both, as we have our conversation, alcohol and drugs being involved. And maybe we can also kind of differentiate between, sort of the surreptitiously given drugs or the voluntarily given drugs or alcohol as well. Those can kind of change the dynamics of the cases a little bit as well.
So yeah, alcohol cases with alcohol, we concede, and we're not going to be pitching you or telling you here that there's a magical bean that's going to make alcohol facilitated sexual assault cases easier. They are difficult to prosecute. There's lots of other difficult things to prosecute too, like robberies or riot cases, or maybe some white collar crime cases. It doesn't mean we give up on prosecuting them. Because something is hard to prosecute, that's usually why a lot of offenders are using those mechanisms or avenues to perpetrate. And so the goal is not to just throw up our hands, but to recognize the challenges and figure out ways we can minimize or overcome those challenges. But with alcohol facilitated sexual assault, these challenges, most prosecutors who've worked on these cases are going to recognize this. Delayed disclosure. Delayed disclosure can be connected with alcohol facilitated sexual assault, or aggravated with AFSA cases, for a lot of reasons. One of the reasons might be the victim is going to be feeling guilty or embarrassed, or they might take it on themselves that it was their fault because they were drunk and that they were assaulted. No or minimal recall. And the minimal recall, it might be caused by the impact that intoxication has on memory, in that it impairs memory. It might also be the effect of compounded by trauma, or just the trauma of being sexual assaulted. But the ability of a victim to remember, or the degree to which they can remember, is prevalent in alcohol facilitated sexual assault. But we do, and we're going to note this later, what a victim does remember when they were a victim of AFSA, while it might be reduced, it's not fantasized. In other words, alcohol, as we're going to be talking about, It can minimize your ability. It can be like a sedative, but it's not an hallucinogen. And the things that happen to you when you're intoxicated, you didn't imagine them happening. You just might remember less of what's happening when you're intoxicated. Victim blaming attitudes. I think I sort of alluded to this before, because alcohol is so socially accepted. The idea that, well, if you're drinking and you're exposed to danger, well, that's your fault for drinking. And so even when the evidence lines up and the law lines up, there can be a reluctance of people to hold accountable the victimization of people who are intoxicated, especially sexual violence victims. Self-blame, I think we can address as well, but also sort of a disbelief on a victim's perspective that they were sexually assaulted, because it doesn't fit into really, I think, a lot of times of the stereotype of what sexual violence looks like that stranger in a trench coat with a knife or gun or something forcing sexual contact.
Yeah, I think it's important to remember that those rape myths that we all recognize to be false, but that we hear and see replayed in popular culture and movies, victims see those things as well. And so when their experience doesn't line up with the stranger in the trench coat, they also may not recognize that what happened to them was rape or sexual assault. I think that disbelief can be heightened when the offenders, as they most commonly are people known to them, people that they trusted, that they liked, that they put themselves in a position of vulnerability in front of. So this disbelief, I think, can be very ingrained and a difficult thing to get over, which of course is part of what leads to that delayed disclosure and that self-blame as well. Those things are all interconnected, as displayed in this beautiful diagram here, the overlapping nature of these.
I love the Venn diagrams, Jane, just because it shows a lot of these things are overlapping. They're not mutually exclusive of one another.
Yeah, and I think that's important too with the trauma piece, because a lot of recent research, which has been incredible, has really given us a greater insight into the impact of trauma on victim behavior, on memory, but it is not that magical bean either, and it does not explain everything. And when we have alcohol involved and trauma involved, the overlapping nature of the responses, and you can't really quite extricate one from the other, so we kind of have to live in this Venn diagram sometimes.
Life is complicated. Real life is complicated.
It is. Okay, so what are the keys to success when prosecuting AFSA? And, spoiler alert, I think these are the keys to success of any case.
Yeah, I agree. And I like that we're using the plural keys rather than key, because there isn't really any one silver bullet or magic bean, whichever
What
phrase
analogy are we
we're
going with
using.
today?
But a lot of it is folks listening to this on some level, you're trying to educate yourself and get a deeper appreciation. I think that's step one. If you're a prosecutor listening to this, having a joint sort of strategy with your investigator who's handling the case to be able to gather this evidence and identify evidence. But really what it is like Jane was saying, it's like any sexual assault case. It's trying to dig out the whole kitchen sink. Doing something more than just getting the disclosure from the victim, maybe getting a statement from the suspect or from the offender, and then being, okay, well, that's it. Do we have enough to charge? Can we prove it? If that's going to be the extent of the investigation, there's going to be a lot of cases that are found wanting. But almost like a homicide is, when there's questions or things you can't answer, you got to be willing to put in the effort to go look for the answers. Recognizing that, hey, look, in terms of a time investment strategy, there might be some things that end up as a dead end. But if you don't go down those routes, you're never going to potentially get the evidence you need to make an informed charging decision about what you can prove or what you're not able to prove. So certainly at a minimum, it's going to be talking to the victim, getting their disclosure, what they're able to disclose. But it's beyond that too. It's looking for these other witnesses in the case. And obviously folks are going to be saying, well, sexual assault, it was committed in private, there was no one there. What are good our other witnesses going to do? But these other witnesses are going to be able to corroborate potentially this disclosure of the victim, either what happened before the assault, sometimes what happened during the assault, maybe what happened after the assault, and approaching it that way. An offender interview, and an offender interview designed towards not just trying to get them, but with the idea of trying to lock them into as much detail as possible, getting their account, learning what happened, listening to the offender, seeing what details or circumstances of the victim's disclosure can be collaborated, and also having an appreciation that an offender being interviewed, now I'm not saying an interview, you have to treat a suspect all the time like they're going to be lying, but at least having an appreciation that a suspect has a motivation to frame themselves in the best light. And especially someone who's going to be a practiced offender. And if you're going to be a seasoned interview, go in with that appreciation and be asking yourself, well, gee, is what the offender is saying, is it supported by evidence? Is it supported by history? With that approach. Ideally, finding the crime scene, recording the crime scene, processing the crime scene with evidence processing techs, seeing what the measurements are, seeing if there's any evidence of what the victim was drinking or consuming or that caused the victim to be intoxicated. What's the state of the area? Is there any sort of physical evidence there that can be recovered? At a minimum, are there some pictures that's going to be able to help the victim tell their story about what occurred to them, or other witnesses tell the story about what occurred, or is going to be able to help the jury understand what happened? Expert testimony, which we're going to be breaking down more fully later on with a toxicologist, but maybe also victim behavior experts that can help educate a jury about victim responses and the dynamics of victim responses to the traumatization of sexual violence. Medical evidence, and I know we just said, well, wait, delayed disclosure. My victim didn't go in time to get a SANE, so what good is medical evidence going to do for me? But maybe medical evidence can help explain some absence of evidence. Maybe jurors are going to be expecting there when a sexual assault occurs, that correlates or corresponds with genital traumatization or some sort of physical trauma. A medical expert's going to be here to help educate the jury about why that isn't necessarily so, and why trauma isn't the sine qua non of whether sexual violence occurred. Jane just laughed because I think I used the word the sine qua non. Hopefully I didn't use it incorrectly.
Dropping Latin, I'm assuming, random times. Okay.
Well, what's going to be embarrassing is if I used it incorrectly and you correct me. But also evidence of trauma too. And by trauma, we're not just talking about physical trauma, but some of the emotional trauma that can accompany, that can help explain, help inform the jury's credibility evaluation of the victim. Like, why is a victim going to be going through all this unless it did happen? But something that I was always interested in, but I know is really Jane's bailiwick, digital evidence. Looking for that, looking for evidence on the phone, looking for opportunities to seize the defendant's device legally, and when appropriately searching that for maybe pictures that were taken, text threads that were developed, maybe not just with the victim, but if there were text threads or communications with the victim, seizing the offender's device to collaborate that, searching it thoroughly. Maybe if they find out, be in a position, a lawful vantage point where you can find out if the offender had communications with other people about the encounter and what they said. Maybe if there's evidence of a drug facilitated sexual assault, is there browser history or app history of them searching for the kinds of substances that can be associated with a drug facilitated sexual assault, etc. Maybe if it's just rather than a specific so-called date rape drugs, and I put that in air quotes, maybe just exposing the victim to making sure the victim had a combination of a narcotic of some kind and alcohol. Gee, well, maybe we can find through a phone an offender having access to those kinds of drugs. et cetera. I mean, is our Supreme Court's recognized in the Riley case, our phones contain an awful lot of our life on them. And when we have lawful authority to seize, and I say lawful authority to seize and search an offender's device, we can find out a lot about the crime.
Mhm.
And in most jurisdictions, if a victim discloses to us there's some text communication with an offender, we're going to have probable cause to seize that offender's device to find if there's corroboration of
Yeah.
what the victim disclosed.
What I think is kind of the key here is not to be so hyper focused on the, the time of the actual assault, and to open our frame to what happened before and what happened after, and the bigger picture that we can paint. Because yes, I think you're right. Most sexual assaults are going to be happening in some sort of private location. So you're not going to have an eyewitness that can sit there and testify, I saw, this sexual contact. But you are going to have witnesses that can say, I saw, the offender talking to the victim all night, buying drinks, offering to drive them home, separating them from their friends that they were previously with. So you have that lens beforehand, and then afterwards, that evidence of trauma might look like, okay, after that night, the victim, never wanted to go out anymore, or the victim went out all the time, and trying to piece together, maybe there's some behavioral evidence of trauma, or other things that we can point to about after the assault. So instead of being that hyper focused, because when you're hyper focused, you may have investigators that say, well, what's the point of doing all this extra work if at the end of the day, the offender's going to admit there was sexual intercourse, the victim's going to say it was non-consensual, the offender's going to say it's consensual. Why bother with all the rest of this if at the end of the day it's going to be, offender says it was consensual, victim says it was not consensual, and that's really all that we have. And I think that sometimes can be where, with a history of, especially if we have a history of like not being successful with these types of cases, we sort of just go, oh, hopeless, that's all we can do. And I think you've just proven by all of this, like, hey, let's widen our focus and make sure that we are treating this case like we would treat any other case that we want to fully investigate to corroborate the victim's disclosure.
And Jane, you made me realize the most obvious thing I forgot to say about what these other witnesses can tell us, especially witnesses from before the assault. How intoxicated was the victim? They saw this victim wasn't able to stand up, dropping her phone, was throwing up or was vomiting here or there, or didn't know, slurring their words or whatever. All this evidence of intoxication that I suppose from people who don't understand what's required here might be like, oh, that makes the victim look bad, that the victim was so intoxicated. But from a prosecutorial perspective, if a victim is too intoxicated to consent, what the offender was saying was consensual intercourse, it isn't going to save the offender's day. If we have all this evidence about how intoxicated the victim was, and evidence that the defendant knew or should have realized how intoxicated the victim was. Especially with the offender interview too, the thing to be so often keep our antenna up for is usually an offender is going to be minimized, or is going to sort of reduce the victim to a caricature about how drunk and sloppy they were and just they couldn't take care of themselves until the offender gets to the moment of sexual contact. Then there's that magic moment when they recovered and consented perfectly. Which again is a manipulation by an offenders who frame it that way, and is evidence that I think we can fairly present as a conscious cover-up by the offender. Like, hey, look, this is that cover-up the offender's trying to do. This is because the offender knew they did something wrong. And so why they're trying to misdirect us as to the victim being in control when they consented is because they're trying to cover up for something they knew they did was wrong. Just as much as when you run away from when a police officer is trying to take you into custody, that's consciousness of guilt.
And that's such a key point to the offender interview. and maybe an offender cross-examination as well, is that they really have, most of the time, they put themselves in a position where they want to sort of blame the victim and paint the victim as drinking too much and drunk and blah, blah, blah. But they can't go too far in that, because they also can't talk themselves into having had sex with a person that was so drunk they couldn't consent voluntarily. And so to try to focus in on how they're trying to walk that line by asking questions like, well, how do you know that she was drunk? And then how do you know she consented? And that's a hard line for them to walk if pressed upon it. So that offender interview, I think is important, and something that, you know, shouldn't be skipped because there is an assumption of what that offender is going to say. And I think that that is something that we have heard of, where this offender interview isn't even attempted because there's this assumption of like, hey, he's just going to say blah, 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 blah.
And
So,
even that's helpful though, too, because a lot of times one of these challenges is trying to prove the physical contact can be a challenge in the prosecution. And look, a lot of times the offender during that interview might admit that physical contact.
right, because you might have a minimal recall on the part of the victim. So you've got the offender talking about that, and now yeah.
And so, yeah, so that physical contact can be an issue, and the offender might be able to provide that element, which, I mean, if you really want to get into the nitty gritty and the esoterics of it, the trade-off about with your investigation about, I know some investigators can be, I like to interview my offender at the end after I've done everything versus the beginning. Usually you're going to have limited opportunities. And even if you don't know everything about the case, interviewing that offender as soon as possible and just getting them locked into something can be critical. And look, if there's an opportunity to interview them again later after you've conducted a more fulsome investigation, that's great. But trying to interview them as early as possible, I think can more often than not pay dividends.
That's interesting. Okay, so on top of this thorough investigation, of course, there is the overlay of how much we as prosecutors know and understand basic toxicology. And we've got a full webinar, 90 minutes, with a toxicologist on our website called the ABCs of BAC. Came up with a very clever name, John. I don't know if you know that. But I want you to cover the basics of toxicology in 1 or 2 slides.
Oh boy, that's not too tall a task. Well, and it's not just prosecutors who don't always understand toxicology. Sometimes investigators don't, and certainly folks on our courts and making up our juries don't always. And one of my biggest regrets are the cases I mischarged because I didn't understand toxicology. And so every time I learn about toxicology, it's like, I wish I would have handled that case or this case differently with this understanding. But the first thing is something we already referenced. Alcohol is essentially a central nervous system depressant. Alcohol works on your body the same way the drugs work on your body when you get anesthesia for surgery. It depresses you. Alcohol, this is important, alcohol is not a hallucinogen. It doesn't make you see things or imagine things. Alcohol isn't a stimulant. Now, you might feel like, oh, well, what about when I get an alcohol-induced rage or, ready to dance or get really active or fun when I drink? How can you say it doesn't get me revved up? And the fact of how it works is still as a depressant, it depresses those parts of your brain, especially in the frontal cortex or cognitive functions that have your inhibitions. And those are the things that are initially relaxed as alcohol is beginning to be absorbed into your bloodstream. And so sometimes that sort of relaxation of inhibitions or depressing of inhibitions can be confused for or misunderstood for a stimulant. Just like the sort of effect alcohol has on depressing your ability to form memories, can be misunderstood as a hallucinogen, and it's not. It's really just shutting down different parts of your brain the more you consume and the higher your BAC spikes. One of the impact is being a central nervous system depressant, as you drink more and absorb more alcohol into your bloodstream and it goes through your brain, it's going to impair your cognition, your judgment, your inhibitions, but also your psychomotor skills, which is why you're going to be stumbling, slurring your speech. In other words, the muscles you need to control your speech are going to be inhibited, as well as the sort of neurons firing in your brain to form speech as well. The other thing that's true about alcohol, well, among the other things that's true, not the other thing, but among the other things that's true about alcohol, as you consume more, it progressively impairs your bodily functions and your abilities. So the more you drink, the more it impairs. I mean, it works on different parts of your brain, but it doesn't move from one section of the brain to the other. Like, okay, as you go to stage 2, it's not impairing your frontal cortex function anymore. It's now going more towards your inner brain. It's continuing to impair all of it. It just gets deeper and deeper into the different functions and portions of your brain.
So even this one slide, I think most people are probably listening and learning or thinking about how alcohol affects an individual maybe slightly differently. This analogy to it is doing the same thing on a different level that anesthesia would do is, I think, really powerful to think about, especially when you might have a case where a very drunk person lies down, and what's the natural thing to do for a drunk person that's in a horizontal state on a couch or a bed? They're going to fall asleep or pass out, right? Instead of all of a sudden being very vigorously involved in consensual sexual activity, which is often what you describe as what an offender might try to tell us. So that's really key. But obviously knowing even more and having a relationship or a partnership with somebody that has more specialized toxicology knowledge could really help our practice of charging and prosecuting these cases. So I thought we could go through some of the things that we would be better at the more that we knew about toxicology.
Sure. Because it's first there, I think one of the things toxicology can help us understand are charging decisions. I mean, how many times are our alcohol facilitated cases reduced to drunk sex? And that's how they're minimized and sort of discounted, like both parties were drunk. The other thing toxicology can help us understand is that how alcohol is absorbed is going to be impacted by body fat percentage, muscle percentage of your body is going to be one thing. And generally speaking, I'm not saying globally or categorically, but generally speaking, a biological female is going to have a greater body fat percentage than a biological male with the same body weight. And what this means is that the higher your body fat percentage is, the more quickly alcohol is absorbed into your bloodstream, or stays in your bloodstream, I should say. The more alcohol is concentrated into your bloodstream and hits your brain, as opposed to the higher muscle percentage you have, the more quickly alcohol will be dissipated from your bloodstream as alcohol seeps into your muscle. So what this means is that for a given weight of a biological male at the same given weight of a biological female, all other things being equal, with the same amount of alcohol over the same period of time, that female is going to have a higher blood alcohol level than that biological male, which is going to make them more vulnerable to the impact or effect of alcohol. And this doesn't even account for, this is only when the male offender represents, I was drunk too, really sort of analyzing that. Were you as drunk? Were you as intoxicated? And were you as drinking as much too? So it can be compounded by that. Toxicology is also going to make us understand a victim disclosure too. So as we listen to a victim disclosure, we want to be listening to the various levels or indicators of varying levels of intoxication. And this is critical because sure, with the initial consumption of alcohol, one of the immediate thing that's happened is going to be the relaxing of inhibitions. And those might be difficult to prove whether a relaxing of inhibitions isn't necessarily invalid consent. But if there's other indications of alcohol that's going to be consumed, such as, hey, a loss of motor skill, bloodshot eyes, what are some other indicators? Continuing lack of judgment is when we get to those levels where physical motor skills are also going to be active. The impact on the front of our brain is going to be more than just relaxed inhibitions, but an inability to make judgments or form judgments, and something that's going to be obvious to anyone who can visibly view. So when we listen to our victim disclosure for these signs of alcohol, it's going to help us understand. And also listening to the victim disclosure too about things they did or didn't do that's going to impact how quickly alcohol is absorbed into their body. How much sleep did they get the day before? How much were they eating or not eating, as the case may be? Whether they were consuming anything else, how tall they are, how much they weigh, so we can figure, not to embarrass them, but so that we can figure out their BMI, and a toxicologist can help us understand, like if we know how much they were drinking, how quickly the alcohol might have been absorbed into your blood. So toxicology is really going to be able to help us understand the disclosure. And personally, I think it's fair to have this conversation with victims as part of a trauma-informed interview. Like, listen, I want to, how much did you weigh? And I'm asking you this not because I want to embarrass you or because I think you're, or body shame you, is because I need to understand how quickly you might have been absorbing or not absorbing alcohol that day. And that's why I'm asking this question. And the victim's going to be, oh, so that's why you're asking, you're not trying to make me shamed.
And I think it's important because sometimes I've worked with victims on cases who say, well, I was drinking, but the effects that I experienced were not in line with my experience and expectation of like how drunk I should have been. Like I had 2 drinks, I should not have felt as drunk as I felt. So we can also kind of negatively figure out, okay, well, this might be a case where there was some additional drugs involved, or there was some surreptitious administration of drugs or alcohol, or it can often also be educating the victim about, are they taking over-the-counter, even allergy medicine, or how the effects of that are. Toxicology also will talk about, not necessarily how much alcohol, but how quickly, what mixers were there. Like it's very different from taking a shot versus, a cocktail versus a glass of wine. And even like carbonation can affect how quickly one's BAC spikes or rises. So like all of that could be really key to this as well.
So, and this helps, and a lot of this stuff is overlapping with toxicology, like analyzing the victim disclosure. Toxicology is also going to help guide us about how we should conduct our interviews with the victim, about what information we want to see, what kind of evidence we want to collect from the scene, which means not just, of course, if there's empty alcohol bottles and things of that nature, let's collect them, but let's also collect receipts. So we can have a timeline and maybe know how long a period a victim was drinking, or how much a victim was eating or not eating that day, things of that nature, or collaborating the things the victim is able to disclose to us too. It obviously help us understand offender behavior, especially if an offender is overstating the level of their intoxication. Because if they're overstating the level of their intoxication, that's really good evidence of consciousness of guilt. Like, why are you overstating your intoxication? So that will give you that sort of societal assumption, like, oh, it was just drunk sex. So if you're overstating your intoxication, that's your cover up. And I mean, personally, as a prosecutor, anytime I found consciousness of guilt evidence, or anything that I could colorably or legitimately frame as consciousness of guilt evidence, that's something I ran with, just because I think that's something juries can understand what offenders do. And if an offender is overstating his intoxication and your toxicology helps us understand that, what a great way to show that cover up.
And that's sort of in the line of the combating defenses as well.
Yeah. So
So-
the same thing and I know we're going to be talking about blackouts and passouts later, but toxicology can help us understand the distinction between those creatures too. So you have a toxicologist. What can you use your toxicologist for? And sometimes your offender might be calling a toxicologist. What can that toxicologist help establish? Because maybe you couldn't persuade your boss to shell out the bucks for a toxicologist, witness, or expert. Maybe you couldn't find one in time, although there are. Please reach out to us. We can get your resources connected to a forensic toxicologist. But at a minimum, things you can hit on cross-examination. This is basic toxicology principles, but that alcohol disproportionately affects women. Again, on the premises about which I was speaking before, the average biological male, the average biological female, and those differences in body fat percentage versus muscle percentage. There are visible manifestations of intoxication. And heck, even your patrol officer who regularly does DUIs and who capably or competently does DUIs can help you articulate the different visible manifestations of intoxication. Like, look, a BAC in 0.12 in person A might be different than in person B. But as you get intoxicated, there are visible manifestations. And what a great way to counter or show like the offender didn't know that she was drunk. Well, there are obvious signs that even a lay person can. Well, most jurisdictions recognize one of the lay opinions that any witness can offer is whether someone appeared drunk, because it's so common in our experiences and our understanding, because there are visible manifestations of intoxication. Alcohol is not an hallucinogen. If you've got a victim who remembers saying no, that shouldn't be impeached because they were intoxicated. If they remember saying no, just like the other things they are able to remember, it's not manufactured or hallucinated because they were intoxicated. Because again, the impact of alcohol is it impairs memory. You won't remember as much. You won't be able to access your memories. It doesn't manufacture false memories. The other thing a toxicologist can establish is only the passage of time removes alcohol from the human body. So there might be sort of a stereotypical belief of, gee, a shocking event can make you sober, such as the shock of being sexually assaulted. That's not true. That's basically that has as much credibility as a flat Earth or phrenology. I may be able to, a toxicologist, if you utilize one, may be able to calculate retrograde extrapolation of what someone's BAC was, if we know how much they were drinking over what period of time, what they were eating, what their weight is, things of that. Same things that experts are usually doing in some DUI cases or DUI homicide cases. And also the effects that alcohol can have on a person, which is going to be critical for establishing the inability of a victim to consent to sexual activity when the offender says this was consensual.
Mm-hmm. Mm-hmm. And as promised, I do want to talk about this idea of blackout versus pass out. I think it's explicitly or implicitly often forming at least a portion of the defense that a defendant may put on. And so what is the difference and how do we deal with maybe both of those?
So a blackout is a person who's intoxicated is conscious, but they're not able to form memories. A pass out is when a person is unconscious. So not only are they not able to form memories, they aren't doing anything because they're effectively unconscious. They're passed out, if you will. How a lot of the times a case can be framed is when a victim remembers or believes they were passed out. The defendant's version of events is, oh, they weren't passed out. They must have blacked out. And during the period in which they were blacked out, the victim gave indications they were consenting to sexual activity, and the victim can't rebut this because they were blacked out. This can be a challenging defense, especially when the defense gets an expert trying to talk about what happens during blackout and the inability to form memories. But there are some things we know about blackouts. When a blackout happens, its association, or at least from what studies have revealed, it's not connected necessarily to someone having a high BAC alone. It more has to do with a quick consumption of alcohol. In other words, getting that BAC spiked up pretty quickly. Maybe someone's doing the 21 shots for their 21st birthday. So in other words, when that I didn't do that, Jane. But when that BAC goes from 0 to 60 in seconds, you're going to be more susceptible to a blackout. A pass out, on the other hand, is going to be more correlated with someone whose BAC is really high, because basically your body is shutting down, and on some level, it's your body's way to prevent from being from alcohol poisoning. So your body's just giving up. A pass out is more akin to being under anesthesia, because remember, we talked about, like the drugs used for anesthesia, alcohol is a central nervous system depressant. So how can you figure out whether or not someone had a blackout or a pass out? Well, when you're building up, what does the evidence show? Is there evidence that the victim was drinking a lot in quick succession and such that their BAC would spike very rapidly? Well, then that could be evidence suggestive of a blackout. If there isn't that evidence, just the victim was drinking a lot over a period of time, then that's consistent with a pass out. But also, if your victim's disclosing after the pass out, feeling groggy and just, well, I guess the legal term is crappy for a period of days or time, that's a lot more consistent with the effects of the high BACs that are going to be associated with a pass out. If there is evidence suggesting there was a blackout, though, that doesn't mean the question of sexual assault is ended, because we don't have to accept the defendant's version of events that during a blackout, the victim consented to sexual activity. Because remember, blackouts are going to be associated with a rapid rise in BAC. At the level of BAC that someone incurs at a blackout, it's not like they are visibly appearing sober. Because remember, the other thing we know from a toxicologist is there's going to be visible signs of intoxication. So someone who is undergoing a blackout is still going to be demonstrating visible signs of intoxication, such that a reasonable person wouldn't think they could consent to drive a vehicle, to sign a contract, or to have sexual activity, or they wouldn't be validly consenting to that, because there's still visible manifestations of intoxication. And those are the things to really be addressing or looking at, is what were the visible signs of intoxication during the time the defense alleges there was a blackout, or when the evidence suggests there was a blackout. And so, hey, look, is there surveillance footage? Is the victim having trouble standing up or control or moving around? These sorts of things that'd be like, oh, well, this looks like a person who could give valid consent to something.
Yeah, it's another place where it's really a thin line that defense has to put forward, which is, oh, this must have been a blackout, which also means this person must have been so drunk and had such a high BAC that you should have known that they were that drunk. Like, it's a hard line for them to consistently walk. But I think because of some of the victim blaming attitudes and the rape myths and things like that, it is an effective defense for many offenders. And so we need to make sure that we're ahead of the game as far as our collaboration with toxicologists, with our own knowledge of it, so that we can really educate our judge and jury about it, and also be prepared for what might end up being a cross-examination of the offender. And hopefully we also have locked the offender into an earlier statement. And all of that is so key to really make sure we're making those arguments. And the analogy that you're talking about signing a contract or driving, I think is something that jurors could relate to if we're effectively presenting our argument as such.
Mm-hmm. So, and a lot of offenders are going to be afraid, oh, I had to help the victim. I got them to their home because they couldn't go by themselves. Well, that's pretty good evidence the offender knew they were intoxicated.
sort of that white knight position that they often put themselves in. How do we take that and turn it around on them? That legal jujitsu.
Yes.
So now the drugs and the alcohol, we were talking about them pretty interchangeably, and I want to explicitly discuss how they're similar and how they're different, and in combination, what are we thinking about? What are we dealing with?
Sure. Well, briefly, drug facilitated sexual assault. What we're talking, they're going to have similar impact on the central nervous system and similar to impact on the body. The things that can be kind of confused with drugs and alcohol is that people think of them having an additive effect. So if you take the incorrect perception might be if you take a stimulant and a depressant like alcohol, they cancel each other out. When in the reality is, as a synergistic effect, they just gives you a wide awake person who's intoxicated. They compound each other rather than canceling one another out, which is why the old saw about giving a drunk coffee is going to sober him up. It'll give you a wide awake drunk. Sticking them in the shower will just give you a wet drunk. So etc. The thing is with a lot of drugs, and drugs is a pretty broad umbrella term because it could be I don't want to say recreational drugs. It could be like the kind of narcotics people use recreationally. It could be the sort of drugs people might use for purposes of facilitating drug facilitated sexual assault. Could be any combination of things, but that they act more quickly and with more potency on the body than alcohol does, which also has implications for the difficulty or challenges in detecting those drugs.
And I think that's kind of our next slide is what happens. And I think, I kind of touched on the fact that we may have somebody who thinks they were drugged and maybe really weren't. But then we also do know that it's so difficult to actually detect many of the drugs that would be used by an offender who is looking to perpetrate a drug or alcohol facilitated sexual assault. And some of those challenges are really technical challenges that we have to be aware of and appreciate sort of the limitations that are out there.
Yeah, the traditional challenges that are still prevalent and recognized today is that, look, a lot of the drugs being used are going to be processing through your body very quickly. And so by the time testing occurs, it's going to be too late to capture them. So that's going to be one challenge. But there's some other challenges too that are inherent to just sort of the sort of shifting targets presented with a drug facilitated sexual assault, and that there's lots of different substances that can be used to facilitate sexual assault. The problem is there isn't one global drug facilitated sexual assault blood test that we can administer. The drug tests or blood tests that we administer to detect drugs in the body are specific to the kind of drug we are looking to detect or that we suspect being used. There's so many being used that one, not every lab or medical facility is going to have access to all of these tests. They might not have available the right one to use or know the right one to be using or the right screening test to use. The other difficulty is too, unlike with something like DNA standards and things like that, even if you do have the drug identified that you're screening for and know which drug you're screening for, the different sorts of tests or commercial tests that are available to screen for that drug, they have different thresholds that have to be met to decide whether there's a positive or negative result. So one screening test for a particular drug might have a positive result when for the same given sample, another drug screening test might have a negative result, just because the quantity in the blood didn't meet the threshold that's required, because there is no standard level. So that's why in the end, if a victim discloses to you something that's consistent with a drug facilitated assault, we really don't want to be too dependent on what a lab test says, or why we shouldn't be discouraged or dismissive of this claim because a lab test or a screening test says no drugs detected, because there's lots of reasons why drugs could have been in this victim's body, but they weren't detected. A combination of reasons. Really what we want to be listening to is to what the victim says. Well, how did you feel? What tell us as much as you can about the substances about the symptoms you felt or how it made you feel. Give me as much information as you can. Find a consulting toxicologist and be asking, hey, what kind of substances could produce this result in a victim? And ideally, when there's opportunity, following up our investigation to see if the defendant or their suspect had explored that substance or use of the kinds of substances or had access to those kinds of substances.
And I was thinking when we talked about the pass out and how the effects could sort of linger, I was thinking that could also affect not only disclosure, but how quickly somebody, maybe sought medical attention. And so again, this delay, that's the offender has caused this delay, and this delay is then causing our inability to detect a drug that might be in the system. So this is all sort of the offender's plan, and it works out. I mean, you've got somebody that is going to, have the effects of being maybe passed out and groggy, and you have all of these challenges, and then that also is going to inhibit their ability to disclose and to have these drugs detected. So again, keeping that offender focus on why we might not have that lab test, but all the other evidence, including the victim's disclosure and explanation of effects that they experienced, are in line with a drug facilitated sexual assault.
Agreed.
So where do we start in these cases? I love the fact we acknowledge that these are really challenging. So where do we start when we think about, okay, this case is in front of us. Is this something that I can charge and that I could pursue successfully?
Well, I think we have a great formulation coming up on the next slide, which is this. Assuming the victim's version is 100% true, do the allegations constitute rape? Does it constitute some sort of sexual contact that either occurred without the victim's consent, and depending on what the law of your jurisdiction requires, when the offender knew or reasonably should have known the victim wasn't consenting? Assuming the answer to that is yes, can we then prove the victim's allegations? And hopefully the answer to the second question is going to be developed through the kind of holistic investigation we were talking about earlier, about looking for ways to corroborate a victim's disclosure. But even so, a lot of times I do want to go back to that first step, because sometimes a victim of an alcohol or drug facilitated sexual assault, they might not be sure if they were sexually assaulted just because they don't have enough memory of what happened or what occurred. Or they might not even be certain there was the nature of sexual or physical contact that happened too. So I would suggest that when we get that kind of disclosure or suggestion from the victim, we don't just limit ourselves to the contours of a victim's disclosure, but I think we do have as prosecutors who are trying to be victim-centered and stewards of public safety, we do have some obligation to go forward and dig into a little bit. Okay, so the victim has got some concerns, not sure what happened or if anything happened. Let's build it out and see where it goes. And if at the end of the day, we can't prove anything criminal happened there, then we leave it at that as an unfinished case. But yeah, I think we do need to carry it further as much as possible.
At first, when I saw this slide, I thought, okay, this seems like super obvious. Why are we having this conversation? But then I started reflecting, and I think we often jump to step 2.
Yeah.
And we start there. And we're so worried about, like, how am I going to prove this? How am I going to get the jury to understand? How am I going to get the jury to empathize and, convict the defendant? And we don't really think about the first step, which is, okay, if this victim's version is true, are we even looking at a sexual assault? And then building that out and spending some time before we ask ourselves the second question of, can we prove it? I think we're so dismissive sometimes on these really hard cases, that we don't do that middle part that maybe needs to be in there, which is that thorough investigation and working with our collaborative partners, like our toxicologists, our investigators, and trying to build out this case before we then ask ourselves, okay, we've done all that we can. We've got this full investigation. We've talked to our expert consultants. Now, are we ready to ask ourselves, can we prove this case?
It's the same kind of approach I think most prosecutors are going to take in a homicide case and building it out. And I think that's a great, that sort of concept or model is a great thing to adapt or employ here too.
Mm-hmm, mm-hmm. And we have some like common sense arguments, and I think these have all been, successfully articulated by our colleagues and our colleagues out there in the field, as well as how do we talk about this to the jury? How do we make these common sense arguments that are going to sort of click with our jurors?
And these are, I think, some of the most, by no means exhaustive, but I think pretty good ones to address, is that a lot of times to sort of take that victim blaming and turn it on its head is intoxication does not cause sexual assault. And maybe this is a topic we should be exploring in voir dire or jury selection, but reframing it and understanding the same thing we were talking about during our offender discussion in our earlier conversation, Jane. Appreciating how the offender identified this victim that was made vulnerable by alcohol and took advantage of that. Look, a reasonable outcome of when you've had too much to drink is maybe losing your keys, losing your phone, singing bad karaoke, or sending an ill-considered text or food order or something of that nature. It's not to be sexually assaulted.
Are you looking at my DoorDash, Jonathan?
I wouldn't presume.
Yeah, I do like
time
that
for
reframing
s'mores
it. It's an offender that's taking advantage or even contributing to this victim intoxication as part of their plan.
Right.
Okay.
And not only how they got access to this victim, but how they isolate this victim that was intoxicated, and how they find this victim who would be discredited. Certainly when we look at the reality, and rather than holding it against victims because they weren't more fulsomely disclosing, understanding some of the barriers involved, including the barriers associated with trauma, but also just guilt and shame and embarrassment. I mean, a lot of people don't want to talk about themselves in their least in control moment. And that's what we're asking victims of alcohol facilitated sexual assault to do. So yes, tell me how you were throwing up. Tell me how you were drinking too much and out of control. Tell me how you were acting that day when this happened. That's going to be necessary. And appreciate that when these victims do come forward, it takes a lot more resolution for them to do that rather than maybe some sort of concocted motive brought by the defense.
And you talked about that as the evidence of trauma that's also can be going through this process, and what it takes to disclose and how it affects your life in so many different ways when you do disclose and you're involved in an investigation, you're involved in a prosecution, and you've had a sexual assault kit administered, and all of that to go forward with this. Unfortunately, it does take this resolute and very strong survivor victim, and to highlight that as part of the presentation to the jury can be powerful, I think. Yeah. It takes a lot to go up and take the stand and go through this process, and I think jurors can get that if we articulate it correctly. Excuse me.
So you want me to cover this part while you
yeah, why don't you cover this part?
All right, so going forward, what we're asking people to do is take the basic understanding of toxicology and apply it to your alcohol facilitated sexual assault and your drug facilitated sexual assault cases. Use it to guide your charging decision, the investigative direction of your case, your victim interviews, and also your trial strategies too. One thing I think we really discussed in this conversation is the necessity to do this most common and complicated of sexual assault cases. It really requires a comprehensive and holistic investigation. It can't just rely on okay, this is what the victim said, this is what the offender said, but it really it requires going down the beaten path and trying to investigate as much as possible. Similarly to as we would for a homicide case, I would hope. And when we do prosecute this case, keep our focus on the offender, use those themes as to how they got access to the victim, how they identified the victim and their vulnerability, and how they exploited that, and how they tried to cover it up too, what their getaway plan was, whether it was minimizing the victim, trying to make them appear so drunk, how they tried to either maybe overstate their own intoxication, what the offender did so that they could get away with this crime they wanted to commit, so they could perpetrate again another day.
Mhm. We have a ton of resources on alcohol facilitated sexual assault. They're not all listed here. A lot of these are written resources that are really valuable if you're preparing for a case and want to dive in. But I'd also suggest the 2 webinars that you, Jonathan, and John, it's the same person. Sometimes we call him Jonathan, sometimes we call him John. And Patty Powers recorded. So those 2 webinars are available. Sadly, we don't have listed here, but I know you'll all remember the ABCs of BAC also on our website. So thanks everyone for listening. I'll let John talk a little bit about the opportunity that AEquitas presents to have these virtual office hours, and then we'll close out with our contact information.
Thank you, Jane, and thank you for the opportunity to talk about office hours. Folks, they're held the 3rd Thursday of every month from 2 to 4 Eastern. And the idea of office hours, it's not a presentation where you just receive information on a topic, but this is hoped to be and idealized to be a conversation with prosecutors from offices across the nation for you to discuss practices and issues that are challenging in your jurisdiction, that you're managed pretty well in your jurisdiction, and just share resources and ideas and brainstorm with one another. Ideally, the analogy I always like to give, just so folks don't go expecting to show up for this and not participating, it's like a good lunchroom conversation where there's a back and forth and brainstorming about a case that someone had that was challenging in court that morning, and ideas about how to address it when it reconvenes in the afternoon. And you can tackle it that way.
I remember those.
I remember those too, where everything
the
seemed
best.
lost at lunch break, and then you have some conversations and you come in with your argument in case law after bouncing it around back in the office, and the judges claps with how persuasive you were. Well, that's how I like to idealize it in my memory.
I'm sure it is. I'm sure it is.
But yeah, Patty, my colleague Patty Powers, and I, we come ready with a topic to sort of help facilitate our conversation, but the forum's really open to anything you'd like to talk about. So I hope you join us.
Yeah, it's a really great opportunity to have sort of this peer network around the country, because nobody needs to reinvent the wheel, and to pull the expertise and experience of others into your practice is always valuable. These are our contact information. Again, John, thank you so much for this conversation, and we'll talk soon.
Great. Thank you, Jane.